Now we turn to Minnesota. Today, the prosecution arrested its case in chief in the federal trial for the 3 former Minneapolis police officers. We also know more concerning which of the 3 defendants plans to take the stand. Tou Thao, Thomas Lane, and Jay King are all charged with failing to provide medical aid to George Floyd, while Derek Chauvin kneeled on his neck for more than 9 minutes. Before resting its case, the prosecution called their most important witness yet, Darnella Frazier, the young woman who recorded the now infamous cell phone video that thrust this case into the national spotlight. My expert panel still with me, veteran prosecutor and BNC legal contributor Paul Henderson and jury consultant Robert Swafford. I want to start with the first witness for the prosecution today, Timothy Longo, a use of force expert who's no stranger to high-profile cases. He's the former chief of the Charlottesville, Virginia police force who previously testified as a prosecution witness in the trial of Muhammad Noor, also there in Minneapolis, and as a defense witness in the case of the officers charged with killing Freddie Gray in Baltimore. Now, Longo testified that an officer's duty of care for people in custody is absolute, because when they're restrained, they can't care for themselves. That the word intervene is a verb requiring action, something these defendants didn't take in stopping the criminal behavior of their fellow officer. Then things got testy during cross-examination. Earl Gray, the attorney for Thomas Lane, started yelling, asking, quote, "What do you expect? That my client, a 4-day veteran, walk over where this crowd is and pick up Chauvin and throw him off? Is that your expectation, sir?" Longo eventually said, quote, "I think someone should have done something." I think Mr. Gray laid it out pretty perfectly. I mean, that's exactly what these defendants should have done. Paul, your thoughts, please.
Yeah, and I thought that was really good, skillful lawyering on the defense part. One, to frame their question with all of those theatrics, and then to contextualize it with behavior that someone might think is ridiculous. But it does not overcome the foundation and the strong foundation that prosecution laid, saying that duty was absolute, that there should have been an intervention, that there was an actual absolute duty from law enforcement, and that law enforcement was not polarized with just one individual. That definition applied to all of law enforcement that was there, engaged and participating in the scene. They were all responsible for what was happening, what they observed, and what was going on around them. And we don't have any ambiguity as to what that was. We've seen it in the video. They all knew. It didn't matter if it was day 4 or day 1. That's why it's important that they have something articulated from law enforcement explaining and describing what the duty was. And again, that duty was absolute given the training, so that the broader jury understands what should have happened. And yes, on day 4, you should have done something. Your job is to be a police officer on day 1, day 2, day 3, whenever, to protect lives, to protect George Floyd, to have done something. And that did not happen. That's why we're here having this trial, along with the other defendants who were officers at the same time and did not take action to prevent him from being killed and to prevent him from dying or interacting in some way. That's why it matters. That was a good witness to call.
You know, theatrics, like you said, it can work, but when you think about what these bystanders were willing to do had Thao not kept them at bay, was to intervene, and that could have been potentially a death sentence, right? But we know with officers, you know, wanting to intervene, wouldn't necessarily end in a death sentence. So I think that argument, that line of questioning, just, you know, honestly didn't work. Robert, how does yelling at it did. Robert, how does yelling go over, or yelling at a witness go over with jurors? I mean, does it signal strength or weakness on the part of the defense?
Well, so it depends on how the witness reacts. So if a witness reacts very calmly and professionally, then it didn't work, because a jury, you know, if a jury's sitting there and they're not sitting there thinking, wow, I wonder what it would be like if I were sitting there cross-examining this witness. They don't imagine themselves in that position. They think, oh my gosh, what would it be like if I were on a witness stand and I were being cross-examined by a lawyer? And so they start out identifying with the witness. Now, if the witness steps off and starts being angry and engaging in the same way, then it actually does work, because they'll give a lawyer a little bit more leeway than they will a witness. So in this situation, it sounds like that the witness is a very experienced witness and didn't take the bait.
All right, let's talk about the prosecution's final witness, Darnella Frazier. She's the reason, basically, why Derek Chauvin was convicted and why these officers are being tried. She's the one who recorded the cell phone video of Chauvin kneeling on George Floyd's neck. Now, Darnella became extremely emotional in front of the jury before she even began her testimony, and the judge gave her a few moments to collect herself, then proceeded. But during the break, one of the defense attorneys expressed concern that Darnella's emotions might have a prejudicial effect on his client. The judge shut that down, saying emotions are a reality. Paul, I mean, this is a girl who is young. I mean, I think she was 17 when she recorded this video. And this is a traumatic experience for everyone who has to, she doesn't want to be there. She doesn't want to be a witness testimony. If she could be anywhere else but that courtroom, she would be. So for the defense to bring that up, I think was insensitive. But again, you know, they're being defense attorneys.
And they're grasping at straws. And obviously, this was an emotional situation because let's not forget, someone died in front of her and she recorded it. And then she's got to testify and come to court. And this is as a juvenile. So, I mean, that just is obvious. This is a traumatic situation and it was a traumatic experience. I understand why the defense would want to point that out. I think a better argument would have been for them to ask her to take a few moments so she doesn't come on the stand and look traumatic, to look traumatized, to look saddened as she begins her testimony. Those are indicators for a jury for credibility. Those are indicators for juries to be sympathetic. And he could have diminished that in a better way than trying to shut her down or trying to shut out that expression of emotion. There are better ways to have done it. And a more experienced trial attorney would have found a sympathetic way to do it, to get her to the stand more prepared to testify and less reactive to the oncoming questions that she's about to face in front of his jury that he wants to influence with his argument. So another misstep from the defense in this case.
Robert, does the defense have a point about the prejudicial effect Darnella could have over the jury? I mean, I can understand that argument more if, say, the prosecution just kept bringing witness after witness after witness in terms of the bystanders that were there that day, you know, sort of being, you know, cumulative with the evidence. But Darnella is an essential part of what happened that day. I mean, the reason why we're even seeing any of that is because of her. So does the defense have a point, though?
No, the defense does not have a point on this. I've prepared really countless numbers of people to testify in very traumatic situations, and I'm thinking specifically about a high-profile case involving sexual assault. And the witness at the end of the preparation session, I said, well, yeah, do you have any concerns that we haven't addressed? And she said, yeah, I have a concern that I may cry. And I said, don't worry about that. You know, if people accept in this situation, this kind of situation, that you would cry. The number one thing that you need to be is authentic. And sometimes you'll have people who have had traumatic experiences, and the way they deal with the trauma is to be robotic or to wall it off. And certainly that's not actually authentic as to what they were feeling inside about the situation. So I would say that crying is actually a part of your obligation to tell the truth.
Guys, before court wrapped up for the day, we learned that Tou Thao and Jay King will be testifying and that Thomas Lane might testify. His attorney says that he wants to talk to his client a bit more before committing. Paul, I thought that Lane was actually going to testify. I believe that's what his attorney had said during jury selection. I could be wrong, but it seemed like Lane, of all the officers, okay, so it seems like Lane, of all the officers, may have a chance of being acquitted because he actually did try to do something, unlike his co-defendants. So you would think that maybe the change of heart is strategy, in that the prosecution maybe, it has failed so far to prove their case against Lane. But with respect to the other officers, is it a smart idea to put them on the stand?
I think whether or not it's smart or not, I think it's something that they feel the pressure to do, because we just ended with that very strong civilian witness that just took the stand, that juvenile. And why that matters is because closing with that witness in particular, right, that is the bystander, is the representation for the jury about what everyone else should have been doing, what reasonable behavior should have happened, that you should have done something because even innocent bystanders did something. They recorded it, they called out, they yelled for it to stop, and they took action when the officers did not. That is a lot of pressure after that witness gets off the stand to reevaluate your case when it's been made clear to everyone else that something should have happened. And I think that's the pressure they're responding to, feeling like they have to tell their side of the case to try and get out from under the implied pressure and judgment from the witness that just got off the stand, that represents the jury and possibly them finding them guilty. That's what I think is going on. I think that's what they're responding to.
Paul Henderson, Robert Swafford, always a pleasure. Thank you so much for your insight and expertise tonight. Thank you.